Good morning, everybody, and welcome to the court show. Yeah, well, here we go. We're doing it again. Those of you guys that have hung with us before, you'll know this is Houston County, Texas versus me. And anyway, we're gonna go through the same old run around the fence pole again, I guess, today. And basically, what's trying to happen is, or what's happening right now is that the hey Rebecca, is that they're trying to convert a charge. They're trying to convert a felony charge to a misdemeanor charge, and the felony charge was trumped up, and that's why we couldn't get any traction on the felony charge. And in Texas, they have 180 days to indict you. If they don't indict you after 180 days, they're supposed to drop and dismiss the case. Well, not if your last name's Tim. Not if your last name's Damron. That just doesn't happen. So this is a common strategy that I've seen in numerous situations where there's a potential for a lawsuit. I'm watching the Leon Valley case. There's a Leon Valley lawsuit that's going on with the previous chief of police there for some false arrest and seizure of property and making up charges and stuff just to try to keep people from suing them. And that seems to be a common strategy these days. So this is another one of those strategies. And basically what happened was these guys came onto trust property, which is trespassing, by the way. And I've got like 8 minutes to explain this, or more. But it basically came onto trust property, harassed me, beat me up, took me to jail for nothing. And just made up charges, stole my property, and then when I went back to get my property, they tried to get me to sign some paperwork to say I received all my property back when I hadn't, and that kind of and then of course when he saw that I have a lapel camera and I'm recording, that clearly escalated things, and that resulted in me getting arrested, beat up, and drugged, and having 2 hemp cigarettes in my pocket. They decided to charge me with marijuana, which is the Spanish version. I don't know why we press 2 for Spanish, but whatever. These people seem to believe that they have 2 years to prosecute this, and today is another attempt to make me plea. This is another arraignment hearing that's been set, and it seems to be consensual, because they refused to give me service. So under Rule 106 and 107. So this seems to be a consensual situation. And these things happen in administrative courts all the time. They will try to trick you and turn on the lights, camera, action, and make it look like it's the real thing, when they haven't done any service, they haven't really done anything, and they're just trying to get you to consent to it. And at this point, that's about all they can really do strategy-wise. However, Tim Damron's not going to like that. So he's not going to go for that. And today is just going to be like all the other ones. Today I will be asking the judge some pretty informative questions regarding my consent. I'm probably going to ask her to recuse herself because I have complaints. I have a complaint filed against her regarding the last hearing, which was not available live. So if any of you guys want to watch that, and that was pretty meaty. I kind of caught the judge and the prosecutor having ex parte communication, and they actually admitted it, walked right into it. So anyway, so it's pretty exciting. I guess it's exciting. It's not really exciting, and it's not. It really sucks, actually. So, I just really invite you guys to, the moral of this story is to stay out of these courts. Ask lots of questions, If you don't have to plea on something, ask. Because I'm going to be asking today. I'm going to be asking what law says I have to plea on this charge. I'm also going to be questioning the court's jurisdiction, considering that the original arrest and charge was a felony. So how did it become a misdemeanor now? Oh, by my consent, that's how it becomes a misdemeanor. So this is a forced consent game is what's happening here. So we're going to watch these guys run around the pole, but at the end of the day, keep in mind, they're doing this because they know what they did was wrong, and they know that they can be sued for it. And that's not okay. That's just not okay. So, anyway, I hope you guys are having a wonderful, wonderful Monday. Besides this, I hope that your day is productive today. You know, I mean, we've got to have those productive days, right? Those are always important. And I am looking for this. There we go. I even have the arraignment by the magistrate. Yep. So, anyway, so we'll get started here. Usually these guys get a little bit late. 2 or 3 minutes past, but, I like to be just ready, just in case. So anyway, we'll see how today goes. I just pray Yahweh's blessing be over all of this. I pray that His truth be the truth of today's discussion. I believe that I hope that it dominates, and it should. It should always dominate. And we just pray this in the name of Yeshua HaMashiach. And I pray for your blessing over all of this today. And I pray that your words be my words today. Heavenly Father, you're so good. We give you praise, honor, and glory in all things. Be with us today. You are and I'm going to tell you guys, if you don't have Yahweh when you're walking into a courtroom, you're in trouble. You're in trouble. Yeah, because these people they might go to church, but that doesn't mean that they're church people. Cockroaches go to church. It doesn't mean that they're serving Yahweh, does it? Not necessarily. They're probably just snacking on the offering plate or snacking on some stuff in the kitchen. Right? So, we got to be good on this. So let's see how things go today. Like I said, we've got about 2 more minutes till go time. I want to thank you guys for being here today. Thank you for witnessing this today. And if you see any inappropriate behavior demonstrated by this judge, I encourage you to file a complaint, not with the bar, with the Judiciary Committee of Texas. This case number is 2012000335. I was arrested and charged falsely, of course, under this 1F01426. And even the affidavit shows a case number of a 190 case number, so we'll see how they want it. Let's see how he thought probable cause existed. Hold on. There we go. Alright. Well, and again, I hope everybody's having a wonderful morning. I hope that Yahweh is blessing your day, your children, everybody. And I hope the rest of your day goes super well. I really don't think this case is going to last very long, because I'm not pleading. So, and I don't think there's anybody in here that can make me do it. So we'll find out. I'm here to tell you there isn't. But these guys are pretty creative. They like to make up stuff. The last hearing we had, we said that we had all kinds of stuff. We're just making up stuff. That's what they do. Kind of like cop-splaining, like judge-splaining instead. I don't know what they call it. But anyway, we're going to get started in a couple minutes. Thanks for joining, everybody. Like I said, if you see anything on here that is not above board, I encourage you to file a complaint with the Judiciary Board of Texas. That's right. It's a pretty easy deal. You can go online and just plug it right in. If you guys want any information on the judge, and all that stuff, I can get that to you. Just send me an instant message. I'm happy to do it. And I'm not telling you guys you should do this because you need to be on my side. I'm telling you you should do this to be on your own side. There might be a day when you're sitting in here, just like me. There's a lot of people that do this every day. So, the better we know our system and the better that we're able to navigate our system, the more accountable we can keep our public servants. Doesn't that sound good? And it's true. It's true. If you know what if you know what your kids are supposed to be doing, you can watch anybody's kids. Uh-oh. Well, now you guys get to see my house. Anyway, yeah, what happened? Well, they called me on the phone probably because they see that this is all on Facebook Live. And because I don't have my headset down here, I couldn't really hear them. So she said they're going to get started in 5 minutes. So, and I'm sure this was just to, break up this little discussion we've been having. But that's fine. Yahweh is mighty. And like I said before, you go walk into these dark places, man. Don't go by yourself. Bring Yahweh with you. And I'm going to set my phone to private. Alright. So I don't get any more calls. It says it'll be about 5 minutes. But anyway, yeah, the other case number, they even put up a case number on it, is 19017-895. But now, we've converted that into something else. And that's not exactly okay. Or legal. But you know what? They don't care. These guys are all about what can we get away with. And here we are. Praise and honor be to Yahweh. Yahweh, we give you all the victory, all the glory, and all the honor. We praise your holy name, and we thank you for all that is good. See, they don't want you recording their stuff.
Marie, I accidentally printed everything. No, I know, I can cancel this too. I'm printing that notice.
Big guns today.
Good morning, Mr. Gamron. Are you here? If you're able to open your computer and
Yes, ma'am. I'm here under special appearance.
do you have video?
Yes, ma'am.
All right, can you open that? I understand what you're saying, but I have denied that motion to dismiss the case. So if you can continue to say that if you like, I don't mind, but I'm not recognizing that. So what we did is we set your case today for arraignment. Are you ready to proceed on arraignment on your case today?
Yeah, I like I stated before, Your Honor, I'm requesting a special hearing. I'm challenging the jurisdiction of this court. I don't believe that the court has jurisdiction to hear case number 190-17895, which is what I was arrested on. This was a felony charge. I have the magistrate, the arraignment here. I was arraigned under 1F01426.
Mr. Cameron, they're not proceeding on that case, though. They decided to proceed on a lesser offense, and that is a possession of marijuana in a drug-free zone, which is a Class A misdemeanor, which this court does have jurisdiction over, and that's what they're proceeding on.
Well, I haven't received notice of that. I haven't received notice of that under Rule 106 and 107.
You received notice of it. We've sent it to you several times, the information and complaint.
But, Your Honor, I'm entitled to proper service under 106 and 107 on any charge, ma'am. And is this bond? I have another question, too. Is this a consensual hearing? Is that why we're not giving me service? Is that because it's like, are you asking for my consent to convert this?
You know what? I've been doing this for a long time, and we've not required. What you're asking for is a relief I've never heard of. But if you want to take it up to the next Court of Appeals and the higher Court of Appeals, you can, okay?
Well, Your Honor, I also filed a request for findings and facts and conclusions under law on April the 15th, which requires an answer from you, respectfully, of course, in 20 days. So, I'm kind of waiting on the answer from that, and then I'm gonna, and then of course we'd appeal it from there, Your Honor. But I was just asking because remember the last hearing you told me you would put the law and you would put how a motion to dismiss could possibly be moot in any situation. You said that code was in my pleadings, but it was not, and I asked you for it repeatedly throughout the hearing. I asked you before you submitted this order to dismiss, I asked you if you would put the law in there so that I could look it up, Your Honor, and you said you would. And I looked at this thing that you sent me in the mail, and I don't recognize this stuff. It's saying that the defendant's motion to dismiss with prejudice, and I also had a motion to strike, ma'am. That was also set too. So we kind of still have this to deal with right now, Your Honor, and respectfully, I'm going to...
Mr. Cameron, I'm denying all your motions. You have the right to have a lawyer. There can be a disadvantage to not having a lawyer and representing yourself.
Okay, ma'am.
You have the right to have a lawyer. You have the right to have a court-appointed lawyer if you are indigent and cannot afford a lawyer.
Your Honor.
If you have the finances to hire a lawyer, you should hire a lawyer with your own resources.
Your Honor.
For arraignment today, my question to you is going to be the same I would ask anyone else that was here for an arraignment. Do you want to represent yourself and sign a waiver of counsel?
No.
Or do you want to hire a lawyer? Or do you want to request a court-appointed lawyer? Those are your questions before the court today.
And I would like to ask the court if I'm here by my own consent or if I'm here by order.
You're here because there's a case filed on the.
And I'm asking you if I'm here by my consent or not, ma'am.
You're here because the state of Texas has charged you with an offense, and you could be in violation of the court order if you're not here. That's what happened.
Do I need to be here? Is there a law that says I need to be here today, ma'am?
Yes, there is, and if you're not here, I'll issue a warrant for your arrest for failure to appear.
But understand that I haven't been served, Your Honor. So I'm asking you: are these matters today? Are they administrative? Are these consensual?
Mr. Cameron, I would really suggest strongly that you hire an attorney or ask for a court-appointed attorney. I think you need a lawyer to assist you with these matters on a criminal case.
Respectfully, Your Honor, I think there's enough of your friends in the courtroom today already, and I don't think we need to have any more. Your Honor, I've already been charged under this case. This case is moot. The matters of this case are moot.
I'm going to need you to be here in person the next time, and I'm going to set it for pretrial. I'm going to take it by what you've said, that you're pleading not guilty to the case.
I'm not pleading anything, ma'am. I'm not pleading anything. I do not plead. I am not pleading on this case. I am not pleading on these charges because the court has not demonstrated that it has, number one, served me for today.
Would you read the information so I can ask Mr. Damron for his plea for purposes of arraignment, since he doesn't want to avail himself to the lawyer?
I'm giving a plea of double jeopardy. Your Honor, I'm entering a plea of double jeopardy today, and I am asking for a special hearing.
I'm going to mute you if you're not quiet. I need you to listen to this session, read the information, okay? And then I need to see if you're going to enter a plea after she reads the information on the record.
In the name and by authority of the state of Texas, I, Daphne Session, County Attorney of Houston County in said state, on the written affidavit of Jerry Kaelin, a competent and credible person, herewith filed in the county court at law in the county of Houston and the state of Texas, do present unto said court that on or about the 16th day of October 2019 and before the making and filing of this information, in the county of Houston and state of Texas, one Timothy Damron, defendant, did then and there intentionally and knowingly possess a usable quantity of marijuana in an amount of 2 ounces or less, and it is further presented in and to said court that the defendant committed the above offense in, on, or within 1,000 feet of a playground, to wit, Crockett City Park in Crockett, Texas, against the peace and dignity of the state, signed by myself, Daphne Session.
Your Honor, I'd like to...
Mr. Damron, how do you plead to the charges that were read out in the information? Guilty or not guilty, or do you need a lawyer?
I have already pled on the matters, Your Honor, and I am asking for a special hearing to determine double jeopardy, that these matters have not already been heard and asked and answered under rule, Your Honor. And that's what I'm asking for. And I am entering a plea of double jeopardy. I believe in my heart that these matters are not on the up and up. I think that this is a strategic move to keep because Daphne, Miss Session, feels like that I'm probably going to sue the city, and I don't think this is okay. I don't think this is right at all. And I'm not entering in a plea on any of these charges because I've already appeared on these charges before the magistrate, and it's right here. And this magistrate arraigned me under a felony arrest and a felony case number and a felony charge. Those matters have expired after 180 days. A writ of habeas corpus has been filed in regards to this matter. So last time when we met and you said, well, you should have filed it with the previous judge, Your Honor, I did. And it has been filed with the previous judge. So that, I mean, we just keep doing this month after month after month.
I'm not going to treat you any differently than I would any other defendant in front of me. You can set that matter of double jeopardy for a hearing, like the pretrial hearing. I will set your case for pretrial today. I'll state on the record that you've not entered a plea of guilty or not guilty at this time to this plea for purposes of arraignment, that you've refused to enter a plea.
That's not true.
You haven't entered a plea today.
I did enter in a plea, ma'am. I entered in a plea of double jeopardy. It's a special plea of double jeopardy, and it is allowed under these circumstances, Your Honor, under rule. And I can quote the rule for you.
Okay, go ahead. Quote the rule for me, Mr. Damron.
And I don't mean to be disrespectful, ma'am. And I'm sorry. I would also request that you recuse yourself from this hearing as well, ma'am. I have complaints filed, and I think that this is a conflict of interest. I think this is a conflict of interest, even with the county clerk being here.
Stop, Mr. Damron. If you want to spend the money to have me recused and me to have the regional judge look at this to see if I should be recused, I will be glad to do that, but you need to put that in writing.
I did. I filed an affidavit giving judicial notice of adjudicated facts, and I filed those with the court. I also filed an affidavit of judicial notice of adjudicated facts pursuant to Rule 201 by complaint regarding the matters of continued oppression and judicial misconduct, conversion, and breach of rights held. Those are affidavits that are already on the court record, Your Honor, and they've been sent.
I don't see where that says that you're asking for Sarah Clark as judge to be recused.
I haven't. No, I have. You know what, Your Honor. You know what? I will get that off to you today. Then, not a problem. I'm sorry. I will clarify that for you. I'm really sorry I didn't make that more clear. But I will do that. But I did file an affidavit, and I'm going to tell you that these matters are outrageous. These are outrageous. I don't have any drug history. I don't have anything. And what I had in my pocket by affidavit shows, the arrest affidavit shows that they were in a hemp box. There was no probable cause to go any further than that. But yet, when Ms. Sessions decides to send it off to the crime lab using my Texas driver's license number rather than my New Mexico driver's license number, which that's a problem too. And then when you look at the articles in there, you can see that there is no box and that there's only one joint in there out of the two and the other one is disbanded. That's called tampering with evidence. I don't even know how we're even going forward with this.
You know what? All of those might be a great defense to you.
They're probable cause defenses, ma'am.
You keep going. We set this case for trial, and a jury will probably find you not guilty based on everything you've told me.
I'm not playing at the casino today, Judge.
You can either do that on your own, or you can do that with a lawyer. And I suggest strongly that you have a lawyer for that.
And, Your Honor, I don't go to the casino because I don't gamble, Your Honor. And if you don't have probable cause for me to be here today, and I'm here under my own consent.
He read the probable cause. You want her to read the probable cause affidavit in addition to the information?
What's the point? If
The point is probable cause. The county attorney on a misdemeanor makes probable cause decision. And they make probable cause decisions and they file the case.
Well, you can set it for another hearing, but the only hearing that I'm interested in is a hearing of double jeopardy, a special hearing of double jeopardy, which I have already issued to court. I've already filed it with the court, and I've already asked for this. I asked for this then. And it's under Article 27.05, Paragraph 4, with Article 32.01 of the Texas Criminal Procedure. None of these are moot under any circumstance. And you said that last time. You said that. You said that it was in my paperwork that my motion to dismiss and this language in here is moot. But yet your order is very vague, doesn't spend any time talking about any laws, anything. But you know what, Your Honor? I got this deal right here, and I'm entering in a special plea of double jeopardy as described in Article 27.04, Paragraph 4, which means unprosecutable offenses, and we need to set a hearing for that. And that is what I'm down to do today.
I'm going to set you for pretrial, and we'll take up any motions then that are filed. And I would strongly suggest again that you have a lawyer to represent you on this case. And I'll give you sufficient time so that you can hire a lawyer before we are set to come to court again.
Can I get Your Honor, can I ask a question?
I will set you at 3:30 on June the 16th.
Can I ask a question?
Yes, you can.
Okay. In the event of a conflict of interest, is there a way, am I going to be able to get a fair and meaningful hearing for whatever day you're setting? So far we haven't been doing it, respectfully. But this next time, are we going to be able to do that?
Mr. Dameron, if you...
There are conflicts of interest here, ma'am.
Mr. Dameron, if you make a valid pleading with me that's recognized under the law, I will review it and give it a pre-trial hearing, okay?
I did that with the motion to dismiss, ma'am, and it has the word shall in there. There's no discretion on that, ma'am.
There's an order denying, I'm not going to argue with you today. There's an order denying your motion to dismiss that I signed after the last hearing. That motion's been denied, and you received that order.
And under rule, Your Honor, I submitted to the court a request for findings and facts and conclusions of law regarding the denial of the movant's motion to dismiss. I'm not a defendant to anything yet. Filed January the 26th and heard April the 1st. See, under Government Code 22004, you were supposed to make a ruling on that in 45 days. And since you decided to strike her response to that, that means the state didn't respond. So that means there is no controversy, and there was no reason for you to not grant that, ma'am, under this section. And under Texas Rule 296...
If you have any pretrial matters, we're resetting your case, and this is concluding the hearing. We're resetting your case for pretrial at 3:30 on June the 16th. And we will send you that notice. Can we send you that notice by email, or do you also want it by mail?
I don't want any of it. And if I don't have to get it, I don't want it. So don't ask me. But if you're just gonna ram it up there, then just go ahead and do what you need to do. But I'm not consenting to any of this. This is gonna, you know what? This is gonna stop.
You're set for pretrial on cause number 2012.
Simulating legal process. I got you.
Versus Timothy Dameron. You're set for pretrial on June 16th at 3:30 p.m. If you'd like it sooner, we can make arrangements for that. But
I don't want it at all, Your Honor.
to talk to a lawyer, to have a lawyer assist you with these matters so that if they are correct, you can.
Asked and answered, Your Honor. You already have enough of your friends in your room already. I don't want any more friends in this room.
Cameron, you're about to be in contempt of court, and I will issue a so-called hearing.
And I apologize, Your Honor.
Overtalk me again. Do you understand that, sir?
I
have a
apologize.
bailiff in here. I have a court reporter on the taking the record. Okay.
I apologize.
Don't interrupt the judge, and you don't interrupt anyone in a hearing. You understand that?
I
I mean,
apologize.
that's just rude in regular life to interrupt somebody. Okay.
Yes, ma'am.
All right. I'm giving you your due process. Your due process to set your case for pretrial. That's set on June the 16th at 3:30. We'll see you then.
Bitches.